A prong of manslaughter. And then we're going to, if the court is overruling that, then we're going to have to spend some time understanding the difference between the two, because it's going to be complicated. But first, my motion is to judgment of acquittal on the A prong, intentionally committed an act or acts that caused the death of Lucy.
Which is what I heard yesterday, I think. That was part of...
That was part of it. And Your Honor had asked some provocative questions about that. And,
Oh, thank you. Okay.
well, many of your questions are provocative, but on that subject, it caught our attention because what is the act, what is the difference between A and C? Let's ask the question that way. You could ask the question,
I mean, I think I understood our conversations and what I based, my ruling on. I denied the judgment of acquittal. The state charged this in the alternative, right? And/or it could be either. So manslaughter could be in their charging document. If they're able to prove manslaughter either by Mr. Pino intentionally committing an act or acts that caused the death of Ms. Fernandez, and/or the death of Ms. Fernandez was caused by the culpable negligence of Mr. Pino. Right. And so your question was, and part of the argument was, what is the act or acts, that caused the death? The defense position is hitting the marker was the act that caused the death.
correct.
Okay.
Because absent the elision, there's no death.
Okay. Understand. And I'm not going to speak for the state, so I think I understood their argument was the act leading to the elision are the intentional acts that lead to the death, such as, Ms. Adams, I think you said, the change of course.
Right, we already litigated that, but yes.
Okay, so, and that's what the state argued would be the intentional act or acts that ultimately caused, that caused the death of Ms. Fernandez. Does that make sense?
Except that the change of course didn't cause the death. It was the elision that caused the death. I understood change of course is the culpable negligence, is putting it on a path towards an elision. It's not, it doesn't cause the death. So at the moment that he changed course, nobody died.
I can't charge the water with causing her death.
That what?
I can't charge the water with causing her death. I mean, we already litigated this. These are what are in the charging document. The court denied the JOA. This is an accurate statement of the law.
So let's go down that rabbit trail. What is the jury under 2A, the act or acts that caused the death? The state is saying now it's enough that he changed course.
I'm not saying that.
Okay, I'm not sure what then the act is that caused the death if it's not the elision. Because typically culpable negligence is the whole course of conduct that puts the passengers in peril, is what typically happens in culpable negligence, driving in a completely erratic way beyond the pale, and something happens, but it was not, it was no intention to crash in a culpable negligence case. If he intended to crash, if the driver intends to crash into the pole, if Mr. Pino intended to crash, let's say that a driver says, I think the Robalo can handle it. I'm going to hit the pole and prove that the Robalo is just as good as a Grady White, that other boat brand. What is the crime? He didn't intend to kill anyone. He thought it was going to survive the crash. He's guilty of culpable negligence if the state proves he's acting with such depravity that even though he doesn't intend to kill someone, that act of elision causes the death.
Doesn't it go to whether something is foreseeable given the conduct?
it would be foreseeable that someone could die if you allied with a marker at 47 miles per hour. So if the person intentionally allied with the marker at 47 miles an hour, that would be manslaughter. It could be murder if it was his intention to kill everybody. If it was suicidal and homicidal, that was his intention. The state's not contending that. There's no evidence of that he intended to kill anyone. The state may be contending, I thought they were contending he wasn't intending to hit the marker at all. That's what they've said before in this courtroom. So if he was not intending to hit the marker, and he was simply intending to go back to Ocean Reef, but because of his failure to act with sufficient care, he was reckless in the way he operated, he accidentally hit the marker, accidentally meaning he didn't intend to, then he's perhaps, that's where the state is pursuing subsection C as a theory of manslaughter. That's how I view the difference between A and C. A was an intention to strike the marker, although without intention to kill him. C is no intention to hit the marker, but driving in such a reckless, forgive me for using that word, culpably negligent manner that it was predictable if you drive blindfolded while drunk at a high speed, you're going to hit something, even if you don't intend to. The best example that I could come up with in my mind in a car, somebody's running away from the police at 90 miles an hour down the interstate. He doesn't want to crash. He's trying to get away. But you go 90 miles down the interstate in the opposite lane through traffic, there's a high probability you're going to crash and kill someone, even though that's not your intent. That's culpable negligence at a minimum, perhaps.
Well, if you, in the driving example, if you're driving on the wrong side of the road, okay, it's foreseeable, reasonably foreseeable, that someone's going to come up on the other side.
Right, and that's culpable negligence.
Okay.
That's different than
But you don't need to be driving at 80 miles an hour to do that, or, weaving, or...
You may be right about just how reckless one has to be, but in either scenario, it was not the driver's intention to have a crash. It was his intention to avoid.
Is it reasonably foreseeable that a crash would result if you stay on the left side of the road instead of the right side of the road?
It could be, but that would be culpable negligence, not under A, an intentional act that causes the death.
Okay.
The causation of the death is the impact.
Okay.
Driving on the wrong side of the road may or may not result in a crash, depending on who's there.
Okay.
So
it's your position, the only applicable subsection would be C.
That's right.
Okay.
Well,
And
reserving my objection, of course, that they haven't proven even that.
Okay.
But A appears not to even be the theory of the state that he was trying to hit the marker.
okay. Now, understanding it's charged, and I'm going to run back to the state on this. Oftentimes, charged in the alternative. It seems that that's how it's charged. So, in terms of the evidence for intentionally committed an act or acts that caused the death of Ms. Fernandez. And one more time for me, the acts that caused the death, beyond the actual impact.
Can I just incorporate the arguments that I made during both of the JOAs? I've already said them multiple times. The court has denied the JOA. The court has already found as a matter of law that the state has proven enough for it to go to the jury.
Right. In your argument, and again, defense finds distinguishing, and there's no way, apparently, from the defense argument to distinguish. It was established X, Y, and Z under subsection A, or alternatively, how they've established under culpable negligence that it's a manslaughter. That's what they're going to argue. And you're going to argue A there's no application at all, and there's no culpable negligence. I think that's how it's going to work out.
Except that, except that there needs to be some understanding of what the word act is under A, that if as a matter of law the act doesn't cause death.
Well, here's the thing. If there was some requirement at least from a legal perspective, from the court's requirement of how to instruct the jury on the law, okay, there'd be a definition, right? And there's no definition here, there's nothing provided by defining what the act is. What the act is, okay?
It has to be that which caused the death.
Okay.
Under A, the act has to have caused the death. That's the definition.
Right.
And so, maybe we should, if we move
How
down.
about this, if Mr. Pino, from the evidence, didn't change course, would there have been an collision? No.
You're saying at the 9-second mark, if he had stayed on the path before the
I think
9-second
before-
mark.
I think before that, wasn't it? Wasn't there a change of course at like 30 something seconds?
I think the state's theory is that at about 9 seconds to impact, there was a change of course that put him on a collision course. That's the state's theory.
So that's the question, right? That's my question. If there was no change of course,
At 9 seconds, he would have
there would be
avoided.
no collision.
That's correct.
Okay, so I suspect